Okay, thank you guys for joining us. We're really excited to have you here today. We are obviously going to be talking about data privacy. We will be having a Q&A session at the end. Feel free to ask your questions using the Q&A box at any point in time you have one. However, we will be answering the questions at the end. So again, ask at any time, but we will be answering them in the last bit of the webinar. My name is Carolyn. I will be your facilitator today, but I am actually going to go ahead and turn it over to Joe, who is the Director of Consulting Services here at RevGen and our data privacy expert.
Hi, good afternoon, everyone. Thank you for your time. First and foremost, before we begin, I want to take a moment to introduce you to RevGen Partners. RevGen Partners is a business and technology consulting firm that helps organizations navigate today's disruptive business environment. The why behind RevGen is very much because we're a values-driven organization that aspires to integrate well with our community and with our customers and lead with respect, integrity, stewardship, and enjoyment. And in doing these things, we basically bring to the marketplace what we call our Q, or our core areas of expertise. The first being customer experience. Everything starts with the experience of your customer. The second being digital enablement and the technology that sits behind that experience. And the third thing is being analytics and insights, the information that you can extract from the digital enablement and those customer experiences. Now, in terms of the folks that are going to be presenting today, of course, I'll be presenting and representing some of my experiences in the area of data privacy. I'll also have my colleague, LaDon, who is a senior consultant with RevGen Partners and is incredibly well researched in the area of data privacy. And she'll walk you through some of her research that she's been conducting, in the area. On top of that, my colleague Laura will walk you through our consulting and implementation model. And talk a bit more about some of the experiences that we've had specifically with customers in helping them, assess and implement their data privacy solutions. But before we begin, let me start with a little bit of a macro level representation of what's happening across the marketplace. So for a number of years, organizations have basically experienced, data breaches and data privacy related challenges. Each of these challenges have presented themselves both in the media as well as in terms of fines that have been levied by governing bodies, which have caught the attention of both executives within these organizations and the collective consciousness of the American folks. The fines themselves have totaled above and beyond the $6.2 billion represented on this slide. And so you could imagine that, this is starting to really get the attention of folks across the industry. Now, when we think about privacy in general, I think it's also important that we, don't give you a full-on history lesson, but it's important to understand how it's progressed over the years. So if you go back to the 70s, that was when, the organizations as well as, countries started to realize an immense amount of data was being collected as a result of advancements in computer science and so forth. So that's when the first modern data privacy laws started to present themselves in Hesse, Germany. And ultimately, Hesse, Germany, they started to pull together laws and protections for consumers. Then in 1983, you started to see some laws that manifested as a result of census and the invasive nature of census data in Germany, and it was called the Right of Information Self-Determination. Subsequent to that, you saw another major initiative called the EU Directive on Data Protection, and that was again one of the very first laws that gave individual consumers control over their data. And so this particular law was implemented all throughout the EU. The only challenge was that when it was implemented in a different way and interpreted in a different way by each EU member state. In 2000, Safe Harbor was passed, which basically governed how data was to be transmitted from the EU to the US and was really implemented as or designed as a result of ensuring that data was properly handled and that there were the right rules of engagement in terms of data relative to intelligence communities. In 2009, the US introduced what's called the Personal Data Privacy and Security Act of 2009. It was a result of each one of the states trying to tackle data privacy on a state-by-state basis. It never passed, but it did lay the foundation and begin, or continue the conversation about data privacy within the US. In 2016, the most comprehensive set of data privacy regulations were passed in the EU called GDPR. The laws basically gave consumers the right to their data, the right to their information and how it is to be used, applied both in a consumer and an employee context, and went into effect in 2018. In 2018, Brazil basically had its own version of GDPR, which again gave consumers and employees the necessary protections around control around their data. Then in 2018, the state of California passed legislation called the California Consumer Privacy Act. It basically was a version, a bit of a pared back version of GDPR, which again gave consumers and employees rights over their data. We'll talk a little bit about it. The employee aspect of the provision was delayed, but it was a step in the right direction towards giving the American consumers and employees the necessary protections relating to their information. In 2020, an extension of that law was passed, bringing CCPA and California privacy into more into alignment with GDPR. And my colleague Ladon will talk a bit about what's available in CPRA, but it's almost at parity with GDPR in terms of functions, capability, and provisions. And then in 2021, the state of Virginia passed what's called the CDPA, or Consumer Data Privacy Act. Very much similar to CPRA, although there is no employee provision in CDPA. And then lastly, the state of Colorado passed what's called CPA, or the Consumer Privacy Act. Again, very similar to CPRA, but without any sort of employee provision. So the net of it is, data privacy has been something that has been top of mind for people, for employees, for organizations, and the marketplace at large since the 1970s, and has progressed quite a bit over the last 30 or 40 years. With that being said, I'm going to ask my colleague Ladon to drill in specifically into what's happening across the US, as she's done quite a bit of research relating to data privacy on a state-by-state basis. Ladon?
Thank you. As Joe mentioned, since 2018 and inspired by CCPA, more and more states are gearing towards having their own consumer data legislations and laws into place. With 36 having introduced at least one legislation, and some of them may have failed or may be on hold, but they're expected to reintroduce them. Some of them are still working through them, like you see on the East Coast. And about 5 have already passed laws, with Nevada and Maine not being comprehensive laws. They're maybe limited to one industry or other limiting factors. And California, Colorado, and Virginia are the ones that already have the data privacy laws. And what we see here is really that we need to expect more movement in this front. So when you are thinking about strategizing around consumer data privacy laws, this is something to have in mind, because more and more states will be introducing, reintroducing, and passing these laws within the next months and years. So that's something to point out here. And I'd like at this point to cover the 3 states that already have laws at a very high level. Could you change slides? Thank you. As Joe mentioned, CCPA, the very first state consumer data privacy law in the US, inspired by GDPR, but it did not go as far as GDPR. And it was fully enforced July 1st of 2020. it has some provisions for our limitations on the usage of consumer data for specific type of marketing practices, but it wasn't very broad. It was just kind of limited, and it included an annual revenue threshold. Again, it didn't go as far as GDPR, but it was a great foundation and a great start for California and other states to improve upon. Last year, California passed an amendment that will be fully enforced July 1st of 2023. CPRA includes some, eliminates some loopholes when it comes to the usage of consumer data for specific type of marketing and advertising. It also modifies the number of data that can be processed or need to be processed or controlled by an organization for them to have to comply with the law, and made other improvements on a high level. But I think what's important when it comes to CPRA right now is that if your organization is compliant with CCPA, now is the time to start running the analysis and doing the assessments that you need to determine what changes you need to make to your processes and infrastructure to comply with this law. And also going back to what we said with the trend that other states have, maybe to think, well, what should I put in place to be more future-proof for other laws that may come my way? So the next state that implemented a law is Virginia, earlier this year in March. Their definition of data is very similar to California. They do remove the annual revenue threshold and make some changes to the definition of sharing data that is not considered sales. So now in Virginia, advertising companies or practices can use some consumer data for specific, operational needs. Now, the very latest is our own state of Colorado that passed the law last month, will become fully effective, except for one exception, I think, on July 1st of 2023. Colorado law is a little different. It has a broader definition of sales of data. It also doesn't only affect for-profit organizations, it also affects nonprofit organizations. And some other entities that may be protected by other laws may have to go back and reevaluate the data that they are storing or processing or selling, because under this law, there is specific language for protection of sensitive data that they made to comply with. That data may not fall under other laws, but they may fall under CPA. And what's important here is the date that I want to highlight. On July 1st, 2023, 2 laws will go into effect at the same time. And on January 1st of 2023, Virginia will go into effect. So 2023 is a very important date for data privacy laws. And that's something I'd like to highlight. If you operate in more than one state, it will make the changes that may need to happen with our infrastructure and processes more complex to comply with all these laws. And the next slide, we are looking at a high level overview of just the scope on consumer rights. And as we talked about the differences between these, this highlights more that they're different, that if you're compliant with one, and now you need to be compliant with other, you have to deal with higher levels of complexity. in infrastructure and processes. And considering that more laws may be coming our way, it really is imperative to start working on what budget you need, resources and time that need to be allocated this year to do the analysis, assessments needed to really implement a future-proof solution for your organization to comply with these laws. Now, all of this complexity in management of data has created the need for organizations to really call for a federal level law. And that one was introduced earlier this year. If we can change slides, please, Joe. Thank you. Earlier this year, Information Transparency and Personal Data Control Act. We don't know where it's going to go or if it's going to pass as it stands today, but it's a great conversation starter. So with that, Joe, I'll pass it back to you.
Yeah, great. Thank you very much for that, Ladon. If you haven't already seen it, much of the research that Ladon was referencing was done with what's called IAPP, International Association of Privacy Professionals. Would certainly encourage you to look at the information that they publish amongst many other resources and assets available. So thank you for that, Ladon. Stemming from that, or as you could probably see, there's a wide variety of states that are looking to progress their own data privacy laws. Obviously, 36 states are still left to, or pardon me, are in the process of doing so. And there's 3 states that have already put provisions in place, right? Along with the opt-in, opt-out that's available in Nevada and Maine. So the question is, if you've already built infrastructure, right, and you are considering the fact that there's a number of different states coming down the pipeline that are going to introduce their own privacy laws, the question is really, how do you make sure that you build your infrastructure such that it can accommodate those new laws? And if you're doing so, should you consider deploying off-the-shelf software to manage this sort of multi-state, multi-law environment? Conversely, if you've taken a build-your-own approach, right, what parts of the Virginia CDPA law or the Colorado CPA law or the California CPRA law do you prioritize in order to future-proof your solution? And really, where should privacy sit on the executive priority list? And all of that should be taken into context of the fines that are being levied, the various legislation and laws that are coming down the pipeline, the enforcement of these laws by the governing bodies like the Attorney General in the state of California, the fact that there's international laws that are also being introduced, right? So where does all of this sit on your priority list, and how do you keep pace with what's going on the IAPP scoreboard and beyond? So in terms of building out the infrastructure, let's take a look at what the business problem would look like, both in the state of California, the state of Colorado, the state of Virginia, and beyond. So you might be a consumer, and as a consumer, you might want to launch a request into a call center, either via phone, email, or the web, or you may have some other means to launch the request into the organization. In doing so, you might have a variety of different access types, right? One being I want to access my information. Another being I want to delete my information. Now, if you've already built infrastructure for CCPA, you've accounted for these 2 items, but the new laws are allowing you to change your information or to appeal the information that an organization has on file. So you'll need to update your infrastructure to account for these things. So this is all of, basically what California, Colorado, and Virginia supports. They also support opt-in and opt-out capabilities. And then also the state of Maine and the state of Nevada support these 2 laws. So when a request is then launched, it's likely routed to a variety of different departments that then have different data elements pertaining to your profile. And they probably have different processes, systems in place to access that information, a variety of different vendor relationships. They also probably have different means for processing that information and pulling it together. Upon pulling it together, you then have to figure out how to assemble that information, bundle it in a way that accounts for not only private, personal information, but sensitive personal information. And then you're going to want to make sure that the file is assembled in a way that it's compliant with the regulatory body or regulatory bodies, and then distributed in a secure fashion, right, using some sort of means to transmit the data back to the consumer. Now, in doing so, you're also going to want to take into consideration that CPRA and CDPA allow for a 12-month look back, and CPRA now allows for an extension beyond the 12 months. The laws also allow for the classification of sensitive personal information beyond just the personal information. So you now have different classifications of data. There's also internal data usage limitations that you're going to want to take into consideration. So you can't just lift and shift a database from a production environment and then restore it in a test environment with the personal information. You can't propagate that PI. You need to make sure that you conduct a risk assessment. And in addition, you need to make sure that you minimize the collection of the data so that it's limited just to the functions that your business needs to conduct. In addition, you need to make sure that the data is portable and that it can be, extracted from your organization, and then the consumer or the individual that's requesting the information can then process it and port it into, perhaps a database on their end. Now, in the environment that I just walked you through, it's probably representing a fairly inefficient operating environment. So you have a bucket of records that you're processing across a wide variety of business units. Each bucket represents some sort of X amount of processing time that you have to take to process each request. Now, if you are operating in a more efficient environment that's perhaps technology enabled, we've been able to prove that you can go upwards of 40% faster in processing that request, such that you can reduce the cycle time it takes to get the information to the requester, and ultimately reallocate that resource time to perhaps other project activities, and perhaps to drive up customer satisfaction in terms of receiving the request in a timely manner. In the environment I walked you through, you might also see that the operating environment is a bit inefficient. Each one of those different business units might have their own source systems, their own data systems, their own processes by which they're handling the data. You might have different data processors or a single data processor that has to account for a bit of a chaotic environment to pull all that information together and to create a comprehensive output file that is compliant with basically the regulatory body standards. That is a bit of a Herculean effort without the proper systems and processes in place, and therefore requires a larger number of headcount. Now, if you're operating in a more IT efficient environment, you probably have a systematic way to receive the request. You've got consistent processing capabilities in place. You've got consistent processes in place. And you have a centralized processor that can always expect the data to be received in some sort of consistent format so that you can create an output file and, if need be, addendum files that are compliant with regulatory body needs. All of which creates an output file for your end user and ultimately reduces the IT headcount necessary to process the file. Now, that more efficient operating environment probably looks a bit more like this. You've got a consumer that goes into a portal or goes into some sort of voice activated system, requests the data, or requests that the data be deleted, or in the new environment, asks for the data to be changed, or for you to launch an appeal with respect to the data that your organization has on profile. It also accounts for minors or opt-in for minors and opt-out to sell or share the information. And the information is then also funneled into the organization for processing on a consistent manner by each department. It takes into consideration this unified process to then funnel the data into that single data processor, creating one single output file or a single output file with a series of addendum files, all in alignment with what the regulatory body expects. And then the information is delivered in a secure fashion back to the consumer. And again, all of that takes into consideration automation of the 12-month and perhaps extended 12-month look-back period, the automation of the data classification, personal information or sensitive personal information, and the automation of that data being portable. It also accounts for a series of processes to limit the usage of the data, conduct the risk assessment, and ensure that there is a limitation on the collection of the data. Now, let's take a look at how you build this environment out, right? So first things first, you very well could have already put in place capabilities from CCPA perspective. And that could be your foundation. Now, you're going to have to consider perhaps extending that environment to account for CPRA, and then extending it to account for the numerous states that are coming down the pipeline with their various legislations. In addition, you might also want to consider an international dimension to the solution you build. And then you're also going to want to consider that, whatever you develop out is going to need to account for innovations in the area of privacy. Okay. Now, in addition to those capabilities, you're going to want to perhaps think about capabilities that are adjacent to data privacy, such as research and readiness, data discovery, consent and preferences, perhaps related to cookies attached to each of your websites, third-party risk management, governance, risk and compliance, ethics and compliance. So my colleague Laura is going to talk to you a bit about the considering a build your own environment versus a standard off-the-shelf environment, how you develop a strategy around data privacy, how you translate that strategy into the actual execution, and ultimately how you build a foundation for data privacy that is extensible on a per state basis, accounts for international laws, accounts for data privacy innovations, and accounts for adjacent spaces. So Laura, I'll hand it over to you.
Okay, thank you, Joe. Okay, so like Joe said, we've talked about legislation, we've talked about the problems that organizations can run into. So now we can talk about exactly how you implement the solution. So you can see here that our implementation strategy here is defined under these 6 steps. We found that organizations can run into certain challenges. So underneath one of these steps, we have each solution that has a result. So our first step is assessment. So basically, this is where RevGen will come in. We execute the assessment, and this is done through a consultation and discovery process. So through that process, you're able to have a financial report that we will have customized for your organization. This will result in strategic recommendations that will help kick off your data privacy project. We recommend always starting here. This gives us a chance to calibrate with you as an organization and to help set your data privacy efforts in motion. Next, you can see we have gap analysis. So this is our step 1. We found often that organizations may not have enough data privacy knowledge or experience. So it's very important that they align on the legislative principles and understand where the organization currently has gaps. This will help you further define your requirements as an organization and will result in a smoother implementation and reduced risks down the road. Our second step, and this is really important because we've seen a lot of organizations struggle here, is that there may be sporadic processes or undocumented processes around where personal information lives. So it's important that you define and understand what your future state process will look like. So through this, you'll improve coordination between the different business groups and reduce your compliance risks down the road as well. Third, we have the consumer experience. So this is basically where your organization decides what you want your consumer experience to look like. This can be anything from policy navigation, cookies, so anything like a cookie banner on the websites, submission monitoring, anything that really the consumer will touch as they're working through whatever data privacy requests they have. By going through this early on, you can improve your consumer experience. Next, we have the technical requirements. So by designing your future state and architecture ahead of time and creating that unified process that Joe just went through, so that has everything to do with people, processes, technology, and data, you will decrease your costs, any architectural challenges and compliance risks. Finally, so execution. This is where you take all of the knowledge and artifacts that you've gained from all those previous steps and execute a scalable solution. So again, we suggest start with step 0, understand where your organization is, and this will set the stage for everything else and for a successful implementation. So as far as what technologies can you use? The benefit of working with an organization like RevGen is that we're able to take an objective look with you at what will work for your organization. So you can see here, we have examples of off-the-shelf and build your own options. So these off-the-shelf options can manage the entire end-to-end process from the receipt of requests to actually creating a consumer-ready file. Like Joe mentioned, the benefit of an off-the-shelf software is that it may be more scalable and help manage this multi-law and multi-state situation. But if your organization decides that you want to go the custom route, there are plenty of technologies and options that you can choose. You can see options like SAP, Microsoft SQL Server. As far as off-the-shelf solutions, we do have OneTrust highlighted. I will speak to that. They are the #1 most widely used platform that operationalizes privacy, security, and data governance. We've actually partnered with them so that we can effectively implement their solution if that is the software that you choose to go with, rather than any other option or build your own approach. So, no matter what your solution is, we can help enable your success by helping you walk through the process and decide what technology or technologies are right for you. I'll turn it back over to Joe.
Thank you for that, Laura. So in conclusion, data privacy is making its way into the collective consciousness of the American folks. One, by virtue of fines that are being levied. Two, by virtue of organizations wanting to take information and data that they have related to consumer profiles very seriously. So keep in mind that data privacy in general is only going to grow as a space over time. Now, we kind of walked through the history of data privacy and the early development of it throughout the 70s, 80s, and early 90s and early 2000s. Right now, we have some fairly sophisticated legislation in place for the state of Colorado, for the state of Virginia, for the state of California, and there's 33 other states right now that are considering passing data privacy laws. In addition, my colleague talked about the fact that the Federal Trade Commission may eventually take over and help manage and implement a federal law related to data privacy. Ultimately, privacy continues to evolve, and one way or the other, the problem will either be solved at a state-by-state level, but also potentially at a federal level. And there's other dimensions to this problem as well, including international GDPR laws, the Brazilian laws, and then other adjacent spaces like consent and so forth that need to be taken into consideration. Now, many of you have already developed a data privacy foundation. The real question is how extensible is that model? How extensible is that technology that you've built? Has it been built to adapt and adopt other states, adapt and adopt international laws? Or does it require you to ultimately fully rebuild a solution that is more extensible to account for the 33 other states that have laws in motion, to account for GDPR, to account for the Brazilian law? These are all questions that we can help you answer as part of our strategic analysis. And so we'd love to sit down with you, and we'd love to have an opportunity to talk to you about data privacy in general, building a data privacy strategy, translating that strategy into a plan, and then ultimately translating that plan into a well-executed project with the appropriate governance model and so forth that my colleague Laura walked you through. So in general, we thank you for your time this afternoon. And Caroline, I'd love to turn it over to any questions that the group might have for the three of us.
Yeah, thank you, Joe. Yeah, definitely. If you have questions, make sure you're getting them into the Q&A box. But we have a couple of here. Can you just speak a little bit more about how this is going to kind of impact the customer experience and customer relationship with my company?
Yeah, great question. So one of the key things to remember is that data privacy presents itself in two forms to consumers and soon to be employees. One is the privacy policy. So how well can a consumer navigate with, for example, your website or your call-in tree and so forth to get access to your data privacy policy and your position on privacy as it relates to the state of California, soon to be as it relates to the state of Colorado and the state of Virginia. So understanding and architecting that experience, it's going to be a very important thing, and how you do it is going to represent to the consumer how seriously you take data privacy. The second aspect of this is the actual portal and call-in capability that you present to the end user. How easy do you make it for them to submit the request to access the data, submit the request to delete the data, submit the request to change the data, or to petition a potential change of the data. All of those things represent the consumer experience on the front end and are going to be quite important in terms of what your brand represents in terms of data privacy. On the back end, accessing the actual information or getting the notification about a data change or a data delete is also going to represent the overall customer experience and how seriously you take the consumer's data and the message that you convey to them. So these are all things that you're going to want to take into consideration and are going to be key consumer touch points that again, play into that customer journey.
Great, thank you. If I've already built a system relating to data privacy that complies with like older regulations, how will I know whether it's better to go for a full rebuild versus going with something that's just building on top of, or going with one of the OneTrust solutions type?
Yeah, great question. So we certainly don't recommend that you have a state-by-state privacy solution, right? You certainly wouldn't want one for GDPR. You certainly wouldn't want one for CCPA extended by CPRA. You don't want an individual one for the state of Virginia, state of Colorado, and so forth, right? So whatever you develop, it needs to be developed in a way that is adaptable and extensible to international laws, to state laws, and so forth. So, we can't say without looking at what you've built, this is the way you should particularly do it, or you need to rip and replace. But what we do know is that, you can do your build your own strategy in a way that is extensible. Or if you adopt off-the-shelf software, you can rest assured that there's been, a great deal of research put into each of those laws to ensure that the actual software in and of itself accommodates and accounts for the laws and the interactions that folks external to your organization have with the request, and folks internal to your organization have with the processing of that information. So I guess in short, Carolyn, it's on a case-by-case basis, but whatever you do, you need to make sure that you build a foundation that you can easily build off of and adapt to, for both state laws, international laws, and I'd go as far as say for innovations in the space as well.
And looks like we have a quick follow-up on that one. In your experience, about how long does it take to adapt a system to one of these new laws?
Yeah, good question. So, basically for CCPA, our experience is it takes, roughly 6 months to get the solution, for example, fully implemented. So to extend CCPA to account for the extensions from a CPRA perspective, you could probably expect that to take about 60 to 70% of the time, because the foundation's already there. But there are some significant complexities in, for example, CPRA. Having your PI data catalog in place and knowing and understanding where every single data element is across every business unit, so that you can account for a change or a contested change. That's not going to be an inconsequential or a small task or activity for the organization to do. So I would say back to the napkin math is you've already got the infrastructure in place, but accounting specifically for that aspect of the law, you should really put a substantial amount of time in place so that you can modify your system to account for that.
And it looks like we have one last question here. Do these laws pertain to where the company is located or to where our consumers are located?
Yeah, good question. It pertains to where the consumer is located. So for example, RevGen Partners is headquartered in Denver, Colorado. However, if RevGen Partners collects information related to people in the state of California or operates and does business in the state of California and meets a number of the thresholds that LaDon walked you through, we are held accountable to the CCPA laws. So keep in mind that it's not where you're headquartered, it's not where your business is located, it's where consumers are and whether or not you're collecting information related to consumers in a particular state that has passed privacy laws.
Okay, I'm not seeing any more questions in the queue. If you have another question, feel free to get it in here in the last minute or so. But Joe, if you'd like to wrap things up.
Well, thank you. And we want to thank everyone for your time. This is clearly a topic that RevGen Partners is passionate about. We'd love to talk with you more about data privacy. And in general, we just appreciate your time and attention today. So thank you very much.